Okay, so I think we can make a start. So it's my great pleasure to welcome Professor Ashley Terlouw. She's Professor of Sociology of Law at Radboud University in the Netherlands. She's chair of a research centre at the Faculty of Law and is responsible for the Institute of Sociology of Law and for the Centre of Migration Law. She's also the chair of the Myers Committee, Standing Committee of Experts in International Migration, Refugee and Criminal Law, the chair of the journal ASYFAIR en Migratierecht.
Migration law.
Migration law, yeah, thank you. And is responsible for the sector plan on conflict resolution, for which Radboud University collaborates with the universities of Leiden and Utrecht. In the past, she's worked at the office of the District Court of The Hague and was the head of the Refugee Department at Amnesty International Netherlands. She has also been a member of the Dutch Committee on Equal Treatment and was a deputy judge at the District Court of Gelderland Migration Chamber from 2011 to 2016. Ashley's main research topics are asylum, non-discrimination, and the working of judicial institutions. And she's published extensively on the administration of justice and migration law. She is supervising various PhD projects, for example, in strategic litigation in asylum cases, externalization of EU asylum law, time pressure on migration law and criminal law judges, country of origin information in asylum procedures, and the treatment of Roma EU citizens. We're delighted, Ashley, that you could join us today, and we very much look forward to hearing your keynote presentation. So I'm going to pass over now to Ashley via Nicole, who's going to play this recorded keynote presentation, and then we'll take questions and answers at the end. Thank you very much, Ashley, for joining us.
Yes, thank you very much, Nick, and also Nicole. I recorded my speech beforehand because the quality is better then.
Dear Nick and other organizers, thank you so much for the invitation to give this speech at your ASYFAIR conference. Dear audience, I'm very honored to have the possibility to speak to you about a subject close to my heart, the dilemma of discretion. Should the administration decide according to the rules or the heart in asylum cases? The legislation always leaves room for interpretation in the law, willingly or unwillingly, explicitly or implicitly. Explicitly by including hardships clauses, canon constructions, or by assignment for further elaboration in policy to the executive. Implicitly by using vague terms like good faith, human dignity, reasonableness, and proportionality. The legislator can choose to give the executive, the administration, a lot of discretion, administrative discretion, which also has some influence on the discretion of the judge, judicial discretion. In my speech today, I will deal with administrative discretion and the dilemma of dealing with this discretion in the asylum procedure. I leave the role of the judiciary aside. To illustrate this dilemma, I will use the Dutch situation in which the State Secretary of Justice and Security struggles with her discretion in asylum cases and cases concerning rooted children. But first, some remarks about the recent Dutch child benefits scandal, in which lack of discretion was a central issue, or lack of use of discretion. As you might know, on January 15th of this year, the Dutch cabinet has resigned due to an escalating scandal over child benefits. More than 20,000 families were wrongly accused by the tax authority of fraudulently claiming child allowances over several years from 2012 onward. as many as 10,000 families were forced to repay tens of thousands of euros, in some cases leading to unemployment, bankruptcies, house evictions, and divorces. The tax authority admitted that at least 11,000 families were singled out for special scrutiny because of their ethnic origin or dual nationality. They had been targeted as a result of ethnic profiling by the tax authority that picked out their foreign-looking names. The cabinet has apologized for the tax office's methods and promised to pay about 30,000 to each family. The cabinet resigned after a devastating parliamentary report titled Unprecedented Injustice, which concluded that fundamental principles of the rule of law had been severely violated. The shocking conclusion of the report was that not only the tax authorities, the executive power, had failed, but also the legislative and the judiciary. And this was all in relation with their notion of discretion. The legislator focused too much on fraud detection and did not provide for hardships clauses. It did not explicitly grant discretion. The executive, the administration, denied or did not use its administrative discretion, both on policy level and street level, and blindly followed the rules. The attitude was that rules are rules and to never deviate from the rules. The judiciary did not use its judicial discretion. The judges easily accepted the harsh decisions of the tax authority and decided that the law left no room for discretion and legitimized the harsh practice of the tax administration. In fact, none of the state powers took responsibility. Central to this scandal were three main forms of injustice. The parents concerned formed a vulnerable group lacking sufficient financial means, often not having Dutch nationality and unaware of the content of the law and of access to justice possibilities. There was a fundamental distrust of the authorities in these people, and the tax authorities made use of digitalized decision-making, which led to neglecting the human dimension and a lack of a proportionality assessment, both by the administration and the judges. We see a remarkable analogy with regard to these three problems in asylum procedures: distrust, a vulnerable group, lack of proportionality assessment, and a dilemma of discretion. Part of the problem lies with the Dutch Immigration and Naturalization Service, the IND. This bureaucratic agency decides on migration law cases under responsibility of the State Secretary, much like the British Home Office works under the responsibility of the Home Secretary. Comparable with the tax authority, the IND has to deal with large numbers of applications and struggles with enormous backlashes. Like the tax authority, the IND has little trust in its clients, and also similar to the tax authorities, the State Secretary is under political pressure to refuse as many applications as possible. And being a member of the Conservative Party, is a proponent of this approach herself. However, like any bureaucratic organization, the State Secretary and the IND for which he is responsible need to have discretion in the way that they interpret the rules and organize their work. Their civil servants, like all street-level bureaucrats, have discretion in the way they deal with individual cases. On the one hand, the executive wants and needs to have administrative discretion. Discretion gives the executive freedom to make policy and to organize the work as they wish. On the other hand, the same bureaucracies fear discretion. It makes them responsible. It causes work. They have to justify their choices. But what is administrative discretion? I identify two forms in this context: policy space and decision space. Policy space is the discretion of the administration to formulate secondary rules within the margins that the law leaves. Decision space is the discretion of the individual decision maker within the administration to decide on individual cases. I will further focus only on the discretion of the Dutch State Secretary of Justice and Security. She has a somewhat complicated role with regard to the separation of powers. Partly she is legislator, she is part of the government, the cabinet. As mentioned, the current State Secretary is a member of the Conservative Party. Partly she belongs to the executive, formulating policy rules. She is responsible for the Dutch Immigration and Naturalization Service, the IND, which takes decisions on her behalf. And in some very specific cases, she takes decisions in individual cases herself. With regard to administrative discretion, she therefore both has policy space and decision space. It is interesting to show that the State Secretary has a curious view on her own discretion. I will illustrate this with two examples. The first example is a situation in which discretion is welcomed by the State Secretary and used extensively. This concerns the way she deals with time limits in the asylum procedure. The second example concerns a situation in which discretion is seen as unwelcome, an unwelcome burden. This is the case when rejected asylum seekers or other unlawfully staying migrants who cannot be deported root in the Netherlands and then claim that due to their specific situation and the passing of time, they should be granted a residence permit. Based on these examples, I hope to answer the following questions. Why is discretion so uneasy for the State Secretary in some cases and so welcome in other cases? How much discretion do we want the State Secretary to have, and when do we want her to stick to the rules? Does discretion lead to arbitrariness or the necessary human dimension? In the end, I hope to show that although the dilemma of discretion seems to be a choice between equal and individual treatment, in fact, both can be realized. The legal rules on the duration of the asylum procedure laid down in the EU Asylum Procedures Directive are on the one hand very strict, but on the other hand leave a lot of discretion to the migration authorities. In a very interesting article, Reneman and Strongs show how the Dutch authorities, the State Secretary and the IND for which he is responsible, use this discretion to differentiate in speed between categories of migrants. They call this temporal discretion, derived from the concept of temporal governance. Temporal governance is controlling and disciplining decision-making processes by means of time. What are the legal rules of this EU Procedures Directive on processing time? The Procedures Directive balances two principles, that dictate the duration of the asylum procedure. On the one hand, the need for fast and simple procedures. On the other hand, the need for a fair and efficient procedure. It is not always acknowledged, but both principles are in the interest of the administration as well as of the individual asylum seeker. This means that the sooner the better is not always true. Too speedy may undermine the quality of decisions. See about this also the read-worthy article of Jessica Hambly and Nick Gill, Law and Speed, Asylum Appeals and the Techniques and Consequences of Legal Quickening. All provisions about time are laid down in Article 31 of the Procedures Directive. This article leaves a lot of temporal discretion. The general rule is to decide as fast as possible, but in any case within 6 months. Article 31, Section 2. However, the immigration authorities may extend the time limits with a further 9 months if a case is very complex, in situations of high influx, or in case of uncertainty about the safety of the country of origin. In any case, the maximum time limit to take a decision is 21 months. Member States may prioritize an examination of an application for international protection, in particular if the application is likely to be well-founded or if the applicant is vulnerable. Article 31, Section 7. These provisions leave the Member States plenty of discretion, but only in the sense that the procedures may go faster, if that is possible, while observing the quality requirements. How does the State Secretary, the Dutch State Secretary, make use of this temporal discretion? Firstly, by extension of the time limits. On paper, the Dutch asylum procedure is one of the fastest in Europe, with a duration of only 8 days. In practice, the IND needs more than 6 months to take decisions in many cases. According to Strongs and Redeman, this is not due to a mass influx, but due to long periods of inactivity before the first interview with the asylum seeker takes place. The State Secretary therefore extended the time limits from 6 to 15 months. Secondly, the State Secretary established different tracks for different categories of asylum seekers. In practice, this meant prioritizing and accelerating cases with low chance of success above cases with high chance of success. So exactly the opposite of prioritizing well-founded cases. Manifestly ill-founded applications, safe country of origin and Dublin cases, are dealt with very quickly, and more complicated applications very, very slowly. Thirdly, the State Secretary skipped the penalty for making decisions too slowly. Until recent, if the IND extended the regular allowed decision time, the asylum seeker could register an objection, writing a notion of default to the IND. If the IND did not decide within 2 weeks after the objection, it automatically had to pay a penalty fee. The asylum seeker can also ask the court to set a new time limit for decision making, after which the IND has to pay a higher penalty fee. This follows from the Dutch administrative law and applies to all fields of administrative law. In practice, the IND did not manage to decide in time, and the amount of money to be paid by the IND increased from 700,000 euros in 2017 to 1.5 million euros in 2018 and 6.6 million euros in 2019. The State Secretary even expected this amount to increase to 17 million euros in 2020 and 16 million euros in 2021. However, the legislator changed the law on penalty fees. Asylum seekers can no longer contest the unlawful prolongation of processing time. Take notice, for political reasons, diminishing of cost, the legislator diminished procedural guarantees for a specific group, asylum seekers. This is how the legislator gave the State Secretary even more room for discretion. This kind of using discretion is worrying in my eyes, because it leads to categorization and very long waiting periods for asylum seekers with more complicated and probably successful claims. Moreover, it leads to more exceptionalism. In migration law, more and more exceptions to general administrative law are allowed and in disadvantage of the individual asylum seeker. And there are no more legal remedies against overrunning the term for decision making. In contrast, I will give you another example of how the State Secretary dealt with her discretion. Until 2019, the State Secretary had the discretionary power to grant a residence status in case of dire cases, even after a final decision of a judge that the claim for a residence permit was invalid. This was meant to be a valve in the law. Long-staying migrants in dire circumstances, but without legal residence, in this way could obtain a residence permit. There was a lot of variation in the way the succeeding State Secretaries dealt with this discretion. Interestingly, one of the most restrictive State Secretaries we had, the former State Secretary Rita Verdonk, also a member of the Conservative Party, used her discretionary power most often. In more than 800 cases, she granted residence statuses based on individual dire circumstances. This even led to a court procedure in which she was accused of arbitrariness. She explained her decisions by pointing at the essence of her discretionary power, which allowed her to grant a residence status to someone who did not fulfill the legal criteria. I decide with my heart in such cases, she said. In fact, she didn't want to reason her decisions in dire cases in fear of shaping precedents. The Amsterdam District Court judged that decisions should rest on criteria which can be tested and which should be laid down in policy rules. In higher appeal, this judgment was confirmed. Since May 1st, 2019, this discretionary power officially does not exist anymore, but not because of the judgment of the Amsterdam District Court. The abolition of the discretionary power was part of a deal between political parties and offered in exchange for the so-called general children's pardon for rooted children. This was a one-off legalization of a specific group of rooted children, often refused asylum seekers without a residence permit. The Conservative Party came to dislike the discretionary power of the State Secretary due to the many cases of mainly rooted children who claimed for residence after a final rejection decision of the judge had taken place. These children often succeeded, partly because of what became known as trial by media or talk show pardon. The often cute and well-integrated children were shown on television shows, and the public started campaigns which in essence exclaimed, "They belong here, with us. They are part of our community." Granting a residence permit for them was on the one hand very dependent on the initiatives of neighbors, teachers, sport teams, journalists who were concerned about the fate of a specific child, and on the other hand, the children's pardon was a way to soften the hard asylum system. Again, we see, as before, in the case of skipping the penalty for late decisions, that the change of rules was a political decision. With a change of the alien circular, the head of the IND is now instead mandated to decide during the first asylum procedure ex officio if the situation is poignant, and to grant a residence permit. In 2019, he granted the status in only 5 dire cases, and in 2020 in 10. Does this mean that the State Secretary really got rid of her discretion? Is getting rid of discretion possible? It should be kept in mind that the head of the IND signs his decision on behalf of the State Secretary. This means that the State Secretary keeps final responsibility. Moreover, the Dutch Aliens Act explicitly leaves discretion in Article 14 to grant residence permits, and in Article 13, which gives 3 reasons to grant a residence permit, one of which is if dire circumstances make this necessary. Nevertheless, the State Secretary denies her discretion. This leads to harsh rules with no room for deviation, proportionality assessments, and tailor-made decision-making, taking into account the human dimension. Like in the first example, in these cases, all other legal remedies are exhausted as well. After all, the cases occur after the final decision of the judge. These 2 examples very much show the dilemma of discretion. The dilemma of discretion is closely related to the dilemma between equal treatment and individual treatment, between efficiency and proportionality assessment in each individual case. The dilemma occurs especially if bureaucracies have to decide on a large number of cases. Large numbers tend to result in digitalized decision-making, and automatic decision-making leads to depersonalization and categorization. What is the difference between the 2 examples? In fact, these examples represent 2 kinds of discretion and the way that is dealt with them. It is obvious. There is a difference between decision space, the discretion to deal with individual cases and to take individual decisions, think of the rooted children, and policy space, the discretion to make rules for categories, the temporal discretion case. The first kind takes time, and the second time, again, the first kind takes time, the second saves time for the administration. The first kind is focused on the individual, but may lead to uncontrollable arbitrariness. The second kind is focused on the general rule, but may lead to injustice in individual cases. And of course, it may also play a role that the use of temporal discretion in asylum procedures concerned admission, and the discretion to deal with dire cases concerns extradition. Let's have a look at the problem of equal treatment versus individual treatment. What is in equal treatment? Liberté, égalité, fraternité. Since the French Revolution, we value equality as one of the 3 main principles for societies. It sounds so easy. Equal treatment in equal cases. What is sauce for the goose is sauce for the gander. However, not every human being is equal, and not every case is equal. The principle of equality is in fact protection of differences. It does not require uniformity. Also, those who deviate from the average should be treated equally if the difference is not relevant. But if the difference is relevant, that difference should be taken into account. This makes the principle of equality in fact very difficult, because what is relevant? Skin color, religion, gender, sexual preference are not relevant. Never? Sexual preference can be relevant if a homosexual asylum seeker from Uganda claims for asylum. Religion can be relevant if a Syrian Orthodox Christian claims to fear for persecution. Gender can be relevant if a Somalian girl fears for female mutilation. And skin color can be relevant if someone with a somewhat darker skin skin color can be relevant if the somewhat darker skin of Hutus makes them recognizable by Tutsis and therefore is a reason to discriminate against them. This shows that every case needs an individual assessment and a treatment according to the particularities of the case. It is the opposite of categorization. This helps us to answer the question how much discretion we want the rules to allow the immigration authorities, the state secretary, and how much discretion these authorities need. In the first place, I repeat what I started with. Rules always leave discretion, as they need to be interpreted. Of course, questions about interpretation of EU rules should be submitted to the Court of Justice of the European Union in order to reach as much harmonization as possible. Too much discretion leads to arbitrariness. But authorities need discretion in order to have room to maneuver, to deal quickly with new situations, and they should never deny their discretion. In common law, we know the so-called no fettering rule, emphasizing the freedom to act of bureaucracies. However, the activities of bureaucracies should always be subjected to a system of control. Make it possible to test if the bureaucracies remain within the so-called belt of restriction. First of all, internal control by peers, team members. They should be open for discussion and contestation. This requires an open culture within bureaucracies. Secondly, they should be controlled by judges. There should always be legal remedies against unlawful use of discretion and even against denying discretion. The lawmakers and professional rulemakers within the executive, like the state secretary, can only make general rules with regard to categories. They need to be applied in individual situations, and for this application, discretion is needed. Of course, in two cases that are completely similar, the same rules should be applied, and there should be a legal remedy in order to claim equal treatment. However, if an individual situation differs on a relevant point, if an individual case if in an individual case a rule leads to unacceptable hardship, there should be room to deviate for the civil servant, the street level bureaucrat, the individual decision maker, and for the State Secretary. But these decisions should also be open for control and therefore be justified, reasoned. I come to my conclusion. Two state secretaries, both members of the leading Conservative Party in the Netherlands, apparently had a completely different idea of their discretion. One of them wanted as much discretion as possible in individual cases to escape the obligation of giving reasons for decisions. The other one denies discretion and wants hard and fast rules for individual cases, but free hands to make policy rules as she likes. How come? On the one hand, we see that discretion is used to influence the asylum procedure by categorizing and longer waiting periods for asylum seekers with high success chances, which at least gives the impression of a political motive to appear restrictive. On the other hand, we see a denial of discretion to restrict the possibilities for rooted, long-staying refused asylum seekers, again based on the political motive to be or to appear restrictive. Legislators and policymakers like the State Secretary can only make general rules, rules with regard to categories. They need to be applied in individual situations, and for this application, discretion is needed. In 2019, the Dutch migration lawyer Barbara Wegeling warned against claims based on the equality principle in a speech under the title "The Round Asylum Seeker, His Lawyer and the Square Rules." Such claims, in her view, are seldom acknowledged by the IND or judges, and if such claims succeed, this forms a stepping stone towards the IND to change its policy and block any future claims. The migrant is round, the rules are square, and decisions could be the migrant is round, the rules are square, and discretion could be the means to make them fit. The law leaves discretion that is unavoidable a good thing. Laws should contain hardship clauses, and if they don't, they should be implied. Restriction of discretion is necessary to reach harmonization. Getting rid of discretion is ridiculous. It is denying discretion. As Professor Emeritus Doreen Pessers eloquently stated in answer to the claim by the earlier mentioned former State Secretary Rita Verdonk that rules are rules, every lawyer and every judge and every decent manager knows that cases seldom are identical. That is why there is always an escape to take the circumstances into account. Protection of the individual against the state is the central meaning of the rule of law. Although the dilemma of discretion seems to be a choice between equal and individual treatment, in fact, both can be realized. Every state secretary, every civil servant, every street-level bureaucrat should be expected and trusted to use their own brains, to take responsibility, and also to be able to give reasons for their decisions. Decision-making by heart sounds sweet, but we at least should know how the heart beats. A short anecdote to finish with. Last week, my daughter gave birth to twins. She had to undergo a cesarean section. She was urgently brought to a hospital in a municipality far from her hometown. The rules say that the father or mother has to register the children in the town of birth within 3 days and show their passport. My daughter was bound to her hospital bed and had no passport with her, only her driver's license. The civil servant of the municipality, however, denied any discretion, and so no possibility for her to make any exceptions. She had to come within 3 days with her passport, disregarding that she was 80 kilometers from home, still very weak, and was not allowed to drive a car due to her caesarean section. Intervention by the hospital and social worker was necessary to make the civil servant aware of his discretion and the meaning behind the rule. Thank you for your attention.
Thank you very much, Ashley, for a fantastic presentation. There's so much in there. I've filled about a page of notes, but just some of the themes that are really jumping out at me, the way that you talked about temporal governance quite near the start, which resonated quite a lot with some of the things that we've been talking about in the rest of the conference. So that's really interesting. The typology of discretion that you set out, I thought was really fascinating as well. I'd be really fascinated to hear what the participants have to make of that. The different approaches of the state actors, the elite state actors to their discretion. Sometimes they want to get rid of it, at other times they recognise it and welcome it. So the welcome and the unwelcome forms of discretion as well. And I think there might be other examples that we can speak to from the asylum cases and the asylum arena as well on that point. And then he talked about equal treatment and how judges shouldn't deny their discretion. I thought that was a very powerful part of the speech as well. You set out some of the grounds for discretion, which is just, I mean, that's the sort of thing that you're able to do because I think of your experience. So that's really very welcome and very provocative as well. And then the necessity of discretion as well. So those are some of the things that jumped out for me. So Ashley, what a fantastic talk. I'm going to take a lot from that, and the conceptual aspects of it as well as the empirical examples. It was very rich, and with your permission that will go on the website as well, so we can return to that.
Thank you very much for the opportunity, Nick. I'm really honored. Thank you.